Good morning, everybody. I'll just wait a few seconds for some of our participants to join us this morning. Not quite as nice as last Thursday, nice and wet here in East Grinstead. I hope you're not having massive employee issues with people not getting to work for fuel shortages and those sorts of things, but another week, another HR crisis, no doubt. But this morning, welcome to the second of our employment webinars on the different types of employment models you might want to be considering. Joining us today from DMH will be Simon Bellum and Adam Williams again. Adam does have the lurgy, so we need to be a little bit kind to Adam this morning. We might need to pick him up during his coughing and sneezing fits, but that's the beauty of live webinars, isn't it? And obviously a clear benefit of Zoom to all of you, that you don't have to be exposed to Adam's coughing and sneezing in person. In the next 50 minutes, we're going to look at a range of options available to you in respect of the different types of employment models. And what we're going to be doing this morning is really looking at the pros and cons and impacts of those options. Now, we can't do a whole session that is deep dive in respect of all of those issues, but we want to highlight the main pros and cons of the different types of employment models. And we're going to do this in a slightly different style than you've been used to. So we're going to do it in a conversational and question and answer type style, with Simon, Adam and myself all getting involved in the discussions. Simon is going to be primary question master. But what we also would like is input from yourselves as well, in the form of any questions that you've got on any of the topics that we're going to be discussing. Then please do raise those questions in the Q&A function and join the conversation, and hopefully we'll have time to answer those questions during the webinar. If we don't answer them during the webinar and during our conversations, then we do promise that we'll put out a Q&A document onto the website during the course of next week. So I am going to pass over to Simon as our question master extraordinaire, Simon, and we can get going on discussing the various types of employment models.
Excellent. So, well, good morning, everybody. First area that we're going to look at is the simple stuff. So direct employment. So I'm going to ask Adam, first of all, what are the main pros and cons of taking on a traditional direct employee?
Well, in terms of pros, I think when you think of legal, maybe also tax perspective, it's certainty in some ways is a key issue. I'll be interested in both of your views as well, but things like certainty that the person has the status of employee, and therefore there's no basis or incentive to end up in litigation or arguments about otherwise if the terms of engagement are correct, and that's how it will be. And from a tax perspective, HMRC don't have any cause to pursue an action trying to assign a different status. So you've got certainty and sure footing as best as you can in general terms as to the nature of the arrangement, and therefore you know what your obligations are. You're much less exposed to the sorts of arguments and litigation we've seen recently with sort of Uber cases, etc. I think also another pro is that employees are subject to a greater number of obligations, including implied obligations, compared to other forms of status. So implied duties of fidelity and not to act in a manner harmful to their employer. And you can obviously hold them to a higher standard than you could legitimately other forms of status. The other point I was going to make was from a practical perspective, I think it's about control and commitment, isn't it? The other forms of status tend to require you to only have, as the engaging party, to only have limited or no relative, almost no control over the individual, how and when they do work, etc. And that's often the thing that undoes the engaging party when you are seeking to establish non-employee status, because you almost always will want an element of control, and if you trip over the line on control, it's often the thing that undermines it being non-employee arrangement. So I think that's something that you don't have to worry about with employee status, and can be very important. And also post-termination restrictions, of course, are more likely to be relevant and legitimate and enforceable, as long as they don't go beyond what's necessary. Did you guys have any other thoughts on pros? I'll pick up a couple of downsides, but I think that's
I think that certainty point, Adam's really important, that whilst you're giving direct employment employees the full gold-plated suite of benefits, and you've got the full suite of obligations, you do know where you are. You're not going to be tripped up at a later stage by someone saying, well, actually, I'm entitled to holiday, or you haven't paid me the national minimum wage, or we don't see somebody that's been given an employment employee contract turning around 6 months later and saying, oh, actually, I think I'm a worker. So actually, I really didn't need these these extra rights you've given me. A direct employee knows where they are. The employer knows where they are as well, and how they're going to do that work and when they're going to do it as well. So absolutely may not be as much flexibility in terms of turning the tap on and off, but everybody knows where they are, and sometimes that's more important in business, to be honest with you, than the flexibility that they might want. I think you've also got issues in terms of with employees, you're more likely to develop them into your mold, your look and feel as to what you want. So sometimes from a branding, from a commercial reputation perspective, it's important to have that degree of control as well. Whereas somebody without that employee status, may have less engagement, and less engagement may be less commitment as well.
I think there's a point there about employer of choice, isn't there? And that if you end up in the courts too much, or you get a name for yourself as an employer on the edge of these status cases, it can start to erode and undermine your reputation as the sort of employer one would want to work for. They're always trying to sort of skew the status and avoid rights that they probably should honour. You've picked up the main downside point there, of course, is that it's the full suite of rights that go with it. But you've got to look and say that might be a fair price to pay for the benefits we've just described. I think that's the key question, isn't it? When we're talking about how we're going to maybe switch up our resourcing model. What's more important to us?
I mean, I think you've hit the nail on the head there, Adam, that it's a question of balance, isn't it? That certainly there are advantages in terms of the discretionary effort that you're likely to get from an employee because of that level of engagement and commitment to the organisation, to their futures in the organisation, and the clarity. But balance that against the loss of flexibility, the fact that it's more difficult to move individuals on. Okay. All right. Well, obviously, looking at the negatives, sometimes things don't work out, and it is a question of moving people on. How, Adam, do you think you manage that risk?
Well, a few different things. Probably three things, I think. I'd be looking. So the contract, I mean, it almost sounds trite, doesn't it? But the contract is so important. You set it up right, give yourself flexibility where you can, and you made that point, Simon. You do lose some of that under the employee arrangement, but give yourself some flexibility. Probationary periods. Do you have shorter notice periods? Put the protections in. And don't go any further than you think you can persuade a court or tribunal is necessary if it's post-termination restrictions, and then follow the terms. Again, it sounds trite, doesn't it? But just certainly for that initial period of employment, the first 2 years, that's going to be crucial, because most of the rights of the employee are based on contract only in terms of termination, etc. Second point would be getting the timing right. If you don't think it's going to work out in long term or it's going to last, make sure you all other things being correct and not creating risks, you bring it to an end by your 103rd week. Before you get tripping into the 2-year mark where you've got unfair dismissal, ordinary unfair dismissal rights. And that's probably linking to the third point. Don't forget that there are some rights that could give rise to challenges around termination, even in that initial period. If you discriminate or are alleged to have retaliated to something that someone's done, which they say is protected.
Yeah. Okay. Right, Adam, moving on. I mean, we talking about the traditional employment model, but we know that there are lots of different flavors of employment model, traditional employment I'm talking about. Fixed term contracts, 0 hours contracts, part-time, etc. So let's talk about this. What are the pros and cons of fixed term contracts in your mind?
I think they can be a useful tool where you need resource for a finite period. And I guess in the big potential upside in that context will be the clarity of the arrangement from the off, managing expectations that might bring with it. And it might also be a means of ensuring you don't accidentally trip over the 2-year mark for unfair dismissal rights. We do find sometimes employers say, got a problem with this employee, we've been trying to grapple with it for a long while, and you ask how long they've been employed and they say 2 years and 1 month. It might be a way of managing that. But it does beg that other question on the slide there about, is it really worth putting someone on a fixed term contract if there aren't obvious reasons to, or why don't you just have them on a permanent contract and then terminate when they're no longer needed? Well, as I say, I think that's a difficult balancing act again, because we should remember that in some ways with a fixed term contract, you're making the legal position more complicated. There's a right to potentially become deemed permanent after a certain number of renewals, unless you can objectively justify why it shouldn't be deemed permanent, and no less favourable treatment compared to a permanent member of staff, which we know between us doesn't come up that often in the tribunals, but it's there, it's sitting in the background. So you do have to think long and hard. I think the main driver might be the employers rather wish to be transparent and not to have an awkward conversation with the employee. So, well, we brought you in on the auspices that you were permanent, but we're having a conversation with you a year later, letting you go. You might find that quite awkward if it appears you kind of always knew that's what you were going to do to me.
So it kind of sets expectations.
Yeah. I think that's the principal advantage.
And so sometimes clients come to us with fixed term contracts, and they say, well, it's for a fixed term, we can just let it end at the fixed term, and that's that. Is it always that simple?
No, it's not, because if you end the employment of a fixed term contract, it's still a dismissal for the purposes of the Employment Rights Act. Of course, not necessarily a problem if you're within those first 2 years, but when you get to the 2-year mark, you're looking at potentially fair reason. Is it fair to dismiss at that point? And based on that reason, are there even redundancy pay arguments that kick in? So that's an important point, Simon, you make, that I think the unwary employer could fall into that trap of, even beyond the 2 years, thinking this is just very easy. We've always said we were going to terminate at this point in time. Just do it. That would be risky.
Yeah.
If you don't think it through.
That's really helpful. Well, moving on. How about 0 hours contracts? What are the advantages of those? As opposed to, for example, having a bank of casual workers.
Yeah, I think the advantage with the bank of casual workers, I suppose, is probably it might help you with one of the principal tricky practical issues with having 0 hours and these casual work arrangements, which is actually managing the certainty of availability of staff. One of the costs of saying we don't need to give you work if we don't have any is you might not turn up when we need you or be available when we need you. And I suppose that having the bank arrangement, you could have a framework and rota around that, which gives you some extra comfort that people understand how and when they might be called upon, and it creates that greater level of certainty. Of course, that does come with risks. The more you structure and have a clear sort of structure and format to your rotoring of bank casual workers, the more you potentially your risk is that they will argue at some point, I'm not really casual, am I? We say that you don't really have to give me work, but look at the bank setup. I always end up working these hours in this week and those hours in that week, and Joe Bloggs there always does the other. This isn't a casual arrangement. And we know that courts and tribunals will look past the written word of the contract and the line that says it's casual, we never have to give you work, you don't have to do it if we ask, and say, does that really reflect the reality of the relationship now? So I think there is a potential benefit, but it comes, like most of these things we're probably going to find today, it comes with a slight cost.
Yeah, and obviously sometimes people start off being on the bank, and then they see a vacancy for a permanent position. They're appointed to a permanent position after being on the bank. Flo has asked, what happens to continuous service in that situation? When does the continuous service start? That's actually a really tricky question, I think. You can obviously contract into continuity. So you may have put in the contract, again, is important. You may have stated in the contract that your employment and engagement for the purposes of continuity starts on the date we first engaged you. You might not have said that and are looking to say that the continuity doesn't apply from day one, but the individual may argue that there's an umbrella overarching arrangement, and I think they may win in that argument. You can't be sure that in every given case you'll be able to say, well, each engagement is a separate discontinuous period of work, and I think you have to be very aware and conscious of the fact that it may be possible to say there's an ongoing underlying arrangement, whether I went from bank to permanent or not. I've been engaged throughout that period. Of course, it will go back to potentially the issue of was my status really one thing all along, rather than did I change into something new? Yeah. Okay. So there are clearly issues of status that you've got to keep your eye on.
Yeah.
I think just a point on sort of the 0 hours. With the 0 hours contract, you've probably got an overarching framework, so you probably can't get away from the continuity of employment argument in the same way you could if you were using a bank of casuals and operated quite a structured break in between the usages of them as well. So if you are using 0 hours, remember that overarching framework is probably going to, put a kibosh on your continuity of employment sort of arguments, and saying that, they hadn't been employed from a certain period.
Yeah, and you've also got those cases about breaks in work activity that are part and parcel of the sector. Simon and I, we've looked at these together in the past, I just recall, where you say if it's ordinary and customary practice for the 2 summer months of the year to be non-working time, you may not be able to say that that's a break in continuity, because that's how this sector and organisation operates. It's a custom and arrangement that doesn't sever the continuity. So it's going to be a very fact sensitive issue.
Yeah. Okay. So obviously we've got to keep an eye on continuity of service. That's a potential worry when we're dealing with 0 hours contracts, or indeed having a bank of casual workers. Adam, finally, just a few bullet points on part-time contracts. What are the main considerations to think about when you're taking on a part-time employee?
Yeah, I think you need to remember the pro rata rules. It's a bit like the fixed term contract, but there are embedded within any part-time employment arrangement additional rights around having an entitlement to pro rata equivalence, and these things can pop up in all sorts of ways. So, for example, you might be giving parking spaces allocated to your full-time staff, and the pro rata rule may create the argument that the part-time worker says, well, I should have an allocating parking space, but then you look and go, I can't actually give the part-time worker an allocated parking space. And we all know how emotive and potentially incendiary the issue of parking can be. So I think you've got to keep that in mind. I think from a more practical perspective, you've got potentially greater complexities around holiday entitlements. How are they calculated? What happens on bank holidays? Are they included or not? You could find from a practical level, it's also harder to deliver the work that team needs to do if you don't ensure the right balance of part-time working. But then that may also raise questions of, If you're not granting certain part-time requests, flexible working requests, will you get a challenge there? Are there underlying family-related reasons for wanting those hours, etc.? So there's a few things to think about. I think also redundancy situations, I'd pick up on that. It sometimes crops up, and it can really make you scratch your head and be a bit of a tricky issue. But if you take an example of, you've got 3 employees in a team, one of them is 0.5 FTE, and you decide you only need 2 FTE. How do you accommodate the 0.5 FTE? Does someone else have to agree to go to half-time as well? Do they have to agree to go to full-time? So that's just one that I just share that because it can come up and kind of takes you a bit by surprise potentially. Of like, we didn't really think of that possible consequence here. How are we gonna make that work?
Okay. All right. Well, thanks, Adam. That's a pretty comprehensive look at direct employment, traditional employment, and often the alternative to the traditional direct employment is self-employment. So, Rebecca, let's start off with a simple one. Is taking on a self-employed individual a risk-free option?
It can't be a risk-free option because hopefully you would have made sure that you've got some contractual arrangement with them. So whenever you've got a contractual arrangement with another party, there are obligations within that contract. So it's really important that those contractual arrangements are representing what you genuinely want, and also incredibly important that you stick to those contractual arrangements, both parties do. So it's a risk-free option in some respect, in that it doesn't give the employee/worker suite of rights, but there are still those contractual obligations, which could end up being more onerous actually than some of the minimum statutory rights owed to employees. And quite often you'll find that self-employed individuals might be more likely to litigate, because often the contract values can be higher. So you do need to be, very careful about what's going to be in that employment contract. In that self-employed contract.
Right. Okay.
I think I would mention on that as well that this sometimes pops up and goes off radar occasionally for employers, but you've got some other statutory legislation that can sometimes bite here, like the commercial agents regulations, where suddenly you realise that, well, we've engaged this person as a contractor or independently, but they are actually, the things they've been doing, they've been negotiating new contracts for us, setting pricing for products that we're selling, and they pop up as a commercial agent and say, well, under the commercial agency regulations, they're entitled to certain indemnities or compensation on termination as well. So there can be unintended consequences that bite, and I think that probably not that well known and not that front of mind for a lot of companies when they engage someone, for example, as someone who's helping them to market their products in a new territory, and the individual might not make the point, maybe deliberately so, because if they did, you'd look and go, crikey, that could be expensive when we come to finish this, so let's not hire this person. But they may well do when it comes to bringing the thing to an end, and say, did you not realize I'm a commercial agent and you need to pay me 2 years revenue to end this? So it doesn't come up that often, but it's, it just shows you that it isn't a risk-free wrapper that you can put around these arrangements by saying self-employed.
Adam, just in literally 15 seconds, what's a commercial agent for the uninitiated?
So a commercial agent can be anybody who is not an employee, but who acts on behalf of the engaging party and has the authority to negotiate contracts, and even potentially doesn't have the power to sign them off, but is able to negotiate contracts, introduce new business on behalf of the employer. And the only way to be sure that they're not an agent in that scenario is for them to be an employee, is the general rule.
Okay, right. So Rebecca, quite often we have a situation where we don't know whether somebody's self-employed or an employee. Let's take a flyer. Let's just take them on as self-employed, and let's not worry about the consequences. What do you recommend to that approach?
Oh, it happens so often. It's a chaotic situation when you have to then come and try and sort it out when it's all gone wrong. And usually it manifests itself in it's all gone wrong when the organisation decides that they no longer want the services of that individual. So they terminate the arrangement. Terminating the arrangement usually then brings up a dispute where the individual is saying, well, actually, I've worked for you for 2 years. I haven't worked for anybody else. Yes, I put invoices in, but it was for a fixed fee on a monthly basis. You told me what to do. I did it when I was told. You paid my expenses. Do you know what? I've gone and sought some legal advice, and I'm pretty sure that I'm a worker. If not a worker, I'm probably, an employee, one of the other. And I've got a classic case at the moment of exactly that scenario, where immediately before a collective redundancy situation, the self-employed individuals were terminated. And that happens quite a lot because there's a reduction of the workforce, and that reduction of the workforce tends to be initially looking at those individuals that you don't think you've got any liabilities to, other than perhaps a notice provision in the consultancy agreement. So that termination of that, in inverted commas, self-employed individual takes place in a relatively, sort of simple meeting basis of, sorry, but, we're terminating your self-employed consultancy agreement. It doesn't take place as part of a fair dismissal process. And because of that, you've almost immediately got an unfair dismissal scenario on your hands. Even if you subsequently find that that individual was a self-employed contractor, you'd probably have gone through 12 months of employment tribunal and preliminary hearings and huge cost, probably all from lack of clarity of the arrangements that both parties should have. And in the case I've got at the moment, we've got unfair dismissal claim, we've got holiday pay claim, we've got statutory redundancy pay claim. We've also got, quite interestingly, a protective award claim on the basis that the individual, the self-employed individual, if they were an employee, should have been included within collective consultation, and they weren't. So it's a really big issue if you do get it wrong. Managing the risk, assess what you're actually needing, not only at the start, but carry on auditing the arrangements of the relationship during the engagement as well. So you can keep putting in sort of checks and markers. And if you find that you've been treating that individual perhaps more like an employee or a worker, kind of dial it back to the self-employed, and sort of actually check out what it is that you intended this individual to be. And
I think also, Rebecca, just keeping a track of how long they've been engaged.
Yeah, exactly.
In so many scenarios, you look and go, well, here's the facts of how they operate, etc., etc. How long they've been doing this for you? And the client says 9 years. And you go, okay. And what? Constantly through 9 years, they've been working in this way. And you go, yeah, well, right. Well, look, my gut tells me we're going to struggle to say there's not something more than a casual contractor and client relationship here. They've been nearly a decade for you. So even if it's just how long have we been doing this? Even that is of value. Better yet, as you say, look at actually what's happening and whether things have shifted.
Yeah. And I think it's always possible to kind of hedge your bets. If you're not certain whether somebody is self-employed or an employee, and you think that there's something of a risk that they are an employee, you get to that sort of redundancy situation that Rebecca is talking about, and you say, right, well, there's a risk there, so we're going to be cautious, and we're not going to acknowledge that they are an employee, but we will treat them in some ways through the process as if they were an employee, to give yourself some level of protection if a tribunal were to find that they were employed.
Yeah, and TUPE, that makes me think of TUPE, Simon, because I see no reason why the same issues Rebecca described wouldn't apply to a TUPE scenario as they would to a collective redundancy. Is or isn't this person caught by TUPE?
Yeah.
Or are they going to argue they are? And if you just terminate the engagement pre-transfer, they have very little downside in arguing, shouldn't have done that. I'm in scope to transfer, automatically unfair, because it's by reason of the transfer, it's not your reason, etc.
Yeah, okay. And what about the duty of care that an organisation owes to a self-employed individual? How does that compare to employees?
It's obviously significantly lower than employees. There's a common law duty of care in terms of matters, relating to health and safety. You've got a self-employed individual on your premises, and you've got what we call occupiers liability duties to anyone that comes onto your premises, and that includes somebody that's self-employed. Some of the statutory health and safety requirements don't extend in the same way because they are very employee and worker specific. So it's probably useful for the contractual arrangements with the individual to have a degree of insurance element in them as well, to sort of almost substitute the duty of care issues. Now, those insurance arrangements in the contract, in the consultancy agreement, they might not only cover insurance for the individual if something happens, to them, but also might cover arrangements if the individual, messes up effectively in respect of the scope of work that they are being required to perform. So yeah, I mean, the duty of care is relatively low in some ways. What I would say, just as some discrimination laws, the Equality Act is a little bit odd with self-employed individuals. Conversely, if a self-employed individual is under a contract to do work personally, which could then tip them into an employee, but if they are under a contract to do work personally, but they are still self-employed, then actually they do have the protections of the Equality Act. And I think it's worth remembering that, because people tend to take a very black and white view on discrimination in self-employed individuals and say, oh, it doesn't apply. But there have been some cases where people have got over the threshold by saying, we are performing our work personally, but we are still self-employed from the employment legal status perspective. So just be a little bit careful there.
Yeah, okay, thanks. Well, we're going to move on now to sort of the linked issue of service companies and IR35, which obviously very much linked to the issue of self-employment. Rebecca, we saw a lot of IR35 concerns a while ago. Can you explain what that was all about, and has it receded, and why?
Yeah, sure. Well, I mean, I think that most employers, most organisations now, when they're looking at their, I tend to call sort of the IR35 sort of self-employed, or almost your corporate consultants. What I was talking about before with self-employed, they're your individual consultants, and the IR35 are your corporate consultants who are providing their services through an intermediary, and that intermediary is normally a personal service company. They've set it up as a limited company, usually because their accountant would have told them to do that. It's tax efficient, or has always been quite tax efficient for them. And there are various ways in which they can then pay themselves from that personal service company in terms of perhaps dividends rather than direct, sort of employee wages. And what we had with our IR35 probably about 6-7 years ago was an introduction in the public sector of HMRC saying, actually, we think people are not necessarily being open and transparent in respect to their tax affairs. In order to ensure we're collecting the tax that we should be collecting, we're going to put the obligation on the end user to collect the tax. Where somebody is providing services through an intermediary, such as a personal service company, and everything is pointing to the fact that, but for that personal service company, they would be in what we call deemed employment for tax purposes. So it is a piece of tax legislation. Being in deemed employment doesn't necessarily mean that you have an employee status in respect of the suite of employment rights you'd expect. So obviously HMRC did it with the public sector. They then moved on to the private sector for medium to large size employers. And from 1st of April of this year, it was delayed 12 months, but from the 1st of April of this year, they implemented IR35 obligations in the private sector. Now, I think because we had the delayed implementation, most employers had actually got their house in order, you know, as at, I think it was April 2020. Those that hadn't, you know, had the benefit of another sort of 12 months to get their house in order. And therefore that meant that they'd carried out audits on their workforce in respect of, you know, okay, well, this person's providing services through an intermediary. We're going to carry out an assessment as to, you know, how they're carrying out those services, what the arrangements are, the reality of the situation. And what we actually saw was quite a lot of sort of the self-employment personal service contracts ended up being terminated, and they were put onto different arrangements. We saw fee negotiations take place in respect of the end users, you know, fees that they were paying, because the end user knew that they would then have to deduct tax and national insurance and apprenticeship levy from the fees that they were paying to those individuals. We saw some consultants sort of working under personal service companies actually being offered employment contracts, because actually when that audit was carried out, it was quite clear that that's what they were. Taking Adam's point about, you know, they'd probably been working there for 9 years, never working for anybody else. And, you know, suddenly somebody in HR starts scratching their head when they find out about the arrangements and says, we are not having this. They are going on to an employed model. So I think that's taken place over the last couple of years. We've also probably seen it recede a little bit as well, because HMRC said, we'll do a light touch approach in terms of any enforcement in the first 12 months, i.e. unless you are blatantly manipulating the system, we'll probably give you words of advice rather than, you know, direct enforcement and collection of taxes from you. That 12 months is going to be up next April, and I don't think HMRC are going to do a light touch. You know, the government coffers is probably a little bit on the light side, so, you know, anything that they can collect, they're going to start collecting in earnest. So, you know, maybe we'll start to see a bit of a ramping up from HMRC of the need to be, you know, 100% compliant from the beginning of next year, and that might mean that organisations revisit this again.
Okay, and just very quickly, Rebecca,
yeah,
how do you determine if an employer has taken reasonable care when they've carried out their status determinations?
Yeah, well, reasonable care, you know, sort of is one of those things that HMRC, the legislation's put out there, and nobody quite knows what it's going to be until the case law comes in. But you know, from my perspective, I think sensibly, you're not discharging reasonable care if the people carrying out the status determinations have no idea what they're doing. So, you know, some training would be good for those people in what IR35 actually is, what they're looking for, in order to understand whether somebody might be in deemed employment. So, you know, training staff who are doing those SDSs is really important. Reasonable care. If you're using the CESS test, HMRC seem to be giving a sort of, you know, a bit of a pass mark on that, provided the information you're putting in is accurate. Reasonable care will mean, certainly if you've taken legal advice, that would probably be deemed as reasonable care. If you've taken some tax advice, if you've also, you know, properly check the info that you're receiving from the individual who has the personal service company, rather than just taking it on face value. So if something looks odd, if something looks wrong, and is so obviously wrong, but you think, well, that's what they've given me, that's what I'll put into CEST, or that's what I'll put into our in-house assessment system, that's probably not going to pass the reasonable care test either.
Okay, great. Right, well, we're going to move on now and talk about agency workers.
Yes, so I'm going to turn the tables on Simon this time and ask Simon a few questions about agency workers. Now, obviously, you know, they're still a very viable option as part of the workforce. But if you're going to use agency workers, Simon, you know, what do you think are the sort of the key benefits of using agency workers?
Yeah, okay. Well, I mean, the obvious benefit to agency workers is the level of flexibility. It's like a tap you, in some circumstances, you can turn on and off. I say in some circumstances because ever so important for all organisations to make sure that their agreements with the agency are well written and in their favour, so that there is a full flexibility in terms of being able to turn that tap on and off and to hire when you need it. That's the big benefit. I think in terms of agency workers, you need to understand that there are some rights and responsibilities which come with engaging agency workers. From day one, they're entitled to information about vacancies in your organisation, access to collective facilities. But importantly, at week 12, sorry, they're entitled to be to have the same basic terms and conditions as if they were employed directly by your organisations. So that means that agency staff are effectively entitled to parity with their comparators who you employ on a permanent basis. Downsides to agency workers is typically the cost, so that there's a third party involved, the agency, they'll want their fee, their cut. So the cost of engaging agency workers can be higher. And then I think we go back to the conversation that we had right at the beginning of the session. What are the advantages of traditional employers? Well, it's that engagement, the extra commitment, the discretionary effort that you'll hopefully get from somebody who's buying into your organisation and sees the long-term future there. Will you get the same from an agency worker? Well, you may do, but probably overall it's likely to be to a more limited extent. So it's that sort of discretionary effort that you may not get from the agency worker. I think it's also true to say that there can be a fair level of confusion in relation to agency workers and the potential liabilities that come along. Who's in control? Is it the agency? Is it the end user? And that can lead to some complications.
Yeah, so I mean, I think agency workers can, they can quite quickly, quite seamlessly sort of integrate into the organisation, and particularly once they've got their sort of week 12 rights, start looking very much like the end user's sort of employee. So sort of where's the line drawn then on responsibility for those agency workers in respect of different issues?
Okay, well, the nature of the relationship is pretty complicated. So the agency worker will be an employee of either the agency or the end user, and typically deciding where the line is to be drawn revolves around issues of control, and where it is the agency that exerts a high level of control over the arrangements in relation to the worker, it's more likely that the agency is going to be regarded as the employer. By contrast, where the end user is exercising a high level of control, it's much more likely to be the end user that would be identified as the employer of those individuals. And the consequence is that the liabilities associated with that employment relationship will either sit with the agency or they will sit with the end user, and very often nobody can be 100% certain. And that reflects the fact that agency workers come in lots of different shapes and sizes. Sometimes they turn up wearing the agency's uniform, they've been trained by the agency, they've been perhaps certificated by the agency in terms of stuff like DBS, and the agency is clearly exercising a very high level of control. Other situations, the agency is very much in the background, and it is the end user that is directing the agency worker. They become incorporated very much in the end user's organisation. And in that scenario, the end user is much more likely to be the employer. The other thing to keep in mind is that when it comes to discrimination, regardless of who is the employer, because of the fairly complicated rules in terms of being responsible for, or a principal being responsible for the actions of its agent within the context of the Equality Act and discrimination legislation, the agency can be responsible for any discrimination on the part of the end user, or indeed the end user's employees. So if an agency worker is subjected to harassment, then there are three potential parties who could be liable: the harasser, the harasser's employer, who's the end user, and indeed the agency. So it's sometimes very difficult to see where the line is drawn.
Well, definitely the most complex of the employment status issues, probably just another layer of complexity sort of added when you've brought an agency worker in.
Yeah.
Sorry, Adam.
Yeah, no, just very quickly, there's another layer of complexity that comes into this. It's amazing how these things, we're going to talk about international element later, about how these things are interwoven in relation to right to work, because now we've had the end of free movement. You might have had an agency sending you an EEA national to do some agency work for you, and in free movement context it wouldn't have mattered. They've got such broad rights to exercise treaty rights in the UK as an EU member state, it didn't matter. Now we're increasingly going to see, and should be aware of the fact that the European national now is subject to immigration control. And the reason I mention it is it's primarily a risk for the agency, but visa sponsorship, the general rule is, do not allow an employer to send someone into another organisation to carry out work. You can't be an employment business. And it goes back to Simon's point. There are limited exceptions where it's a defined time-bound project, and the employer sending the person in, i.e. in this context, the agency, retains all the control of what the individual is doing and when. So I think whether you're the agency business or the end user, you've really got to be careful about what's the nationality of the individual, who's got control of them here. And you may need to be asking questions then of the agency, are you sponsoring this individual for a visa? And if so, and I say that because the end user might not have the primary risk around illegal working penalties and all those sorts of things. But if nothing else, the whole agency arrangement may unravel if suddenly the Home Office say, this is contrary to your sponsor rules, agency, this person needs to go home now.
Yeah. Okay, Adam. Yeah. That takes us seamlessly onto the quote to international workers. So, first question: trying to draw a comparison between the cost of engaging local labour as against going for a visa sponsorship.
Yeah, it's a really tricky issue. Probably one that a lot of employers are really starting to grapple with in a way they hadn't before, of course. And factored in is the shortage of labour and all those issues. I think to give a rough idea, excuse me, that the common route here would be sponsorship under a skilled worker visa. Well, in that regard, if you were looking at a 3-year sponsorship for someone, which you could then extend for a further 2 years, and at the 5-year mark, they might be able to get settlement in the UK and you'd no longer have to sponsor them. You're probably looking at £2,000 to £5,000 of on cost just for the visa bit. So £500 to £1,500 for your 4-year sponsor license, £1,200 to £3,000 for the tax, or it's immigration skills charge, but you pay that up front in respect of however many years you're sponsoring, £200 for the certificate of sponsorship. So somewhere between 2,000 and 5,000 is a very rough and ready of on cost, but that assumes you won't be covering the employee's own visa application fee and their immigration health surcharge. That could add another couple of thousand on, even without relocation expenses. So you're definitely into the at least the low thousands. So it's you've got to weigh that up against the cost of looking locally, and do you develop people here, and what will you get at the end of it? What sort of resource are you going to end up with? Yeah.
Okay. And how about the employment relationship? Does visa sponsorship change that very much? Are there any advantages just beyond accessing the broader talent?
Well, visa sponsorship won't change it. Almost certainly you will be down the route of employer-employee, just because of the nature of visa sponsorship, and that you have to have a role that qualifies, and somebody filling a role in the UK, a genuine vacancy, so to speak. So it doesn't change the underlying relationship. It probably dictates a bit the status, and you'd be in the employee territory almost certainly. I mean, a bit of an advantage around retention. It's less of a powerful thing now since 1st of January than it was. And without boring people too much with the technicals, that's because from January, if someone wants to change employer and they were sponsored, it's no longer the case that the new employer has to do an advertising process in the UK and show no one else here fits the role. That's gone, but it's still typically harder for a sponsored employee to move employers. They've got to find a sponsor with a license. They've got to find a suitable role within that sponsor who has their PBS license and is able and willing to sponsor them in what we call a change of employment application. So generally speaking, sponsored employees are going to be more sticky to you. And that, I guess that could be of real value for certain employers in certain sectors. You know, we can be more confident this person will stay with us in the longer term. And I guess you factor that into your cost benefit analysis as well, don't you?
Yeah, sure. Okay. And then just quickly, Adam, because we're running quite close to time. What about the relationship between international workers and apprenticeships?
It's definitely something to explore very quickly. There are minimum skills requirements, but when you're identifying your role that you're going to employ someone for and whether it qualifies for the minimum skill level, in the trainee sort of apprenticeship contest, the ONS rules say, look to the role that they're working towards rather than their trainee status. So solicitors, for example, if you're sponsoring a trainee solicitor, you look at the role of solicitor as your qualifying skilled role. So definitely one to keep in mind.
Right. Okay. Right. Well, let's look next at interns and volunteers. Rebecca, lots of advantages to people taking on internships. From an organisation's perspective, what do they need to be thinking about?
They need to think about the duration of that internship. They need to think about what that intern is actually going to do. So are they simply work shadowing and observing, or are they going to end up effectively, doing somebody's job that they would otherwise have recruited perhaps a direct employee for? They need to think about, are they going to pay them? Is this going to be an unpaid intern? If it's going to be an unpaid intern, then they need to think even more carefully about what they're going to do in terms of the scope of work, because there's no point paying an intern, a couple of £100 perhaps, for their services, and then finding, well, actually that was below the national minimum wage. And they've found themselves in a sort of a real sticky situation there, because I think with both interns and volunteers, which we'll look at in a moment, there is no specific employment legal definition of what an intern is or what a volunteer is. So you still have to go through the whole employment status test of going, are they an employee, are they a worker, or are they neither one of those? If you've got, interns used to be, cheap, free labour for organisations, and individuals are very happy to go and get that experience on their CV because it helped them with their next job. We've got a little bit more, I think, fairer in terms of interns. We've had some government, proposals as to regulating the organisations that use them. But, you will still have situations where, there is a sort of an exploited individual going into an organisation and 6 months down the line, not only have they not been paid for doing, a hard day's work, but they've not been provided with any sort of expenses in terms of travel expenses or, other things that are, necessary for the discharge of their services. Now, with interns, you can, you could pay some benefits in kind and still keep them as non-employees and non-workers, provided those payments aren't necessary for the provided the payments are necessary for the discharge of their services. So if you sent an intern, from your office to deliver something perhaps to a client, then paying them, their tube fare is fine. But if you start paying those interns, travel and accommodation expenses that have nothing to do with the performance of their services, then you're going to be, putting them perhaps in the realm of an employee/worker. But I would say keep the intern periods relatively short. Really watch how they're being paid. And also, avoid things such as, a requirement that they have to be, at a particular place at a particular time and carry out particular duties, because otherwise you're going to get within the control tests of an employee, the mutuality of obligation tests, and, you're going to find that you come unstuck with things, particularly like national minimum wage and holiday rights.
So quite clearly it's a question of status. You have to look very carefully at any payments made to interns.
Yeah.
Right, 2 bullet points, please, Rebecca. Volunteers, what are the main red flags?
Suggest rather than demand. Volunteers are exactly that. If they want to walk out, if they're volunteering, then they can jolly well walk out of their volunteering. It might not be a very nice thing to do, but if you're saying, again, saying you have to do this at this point in this way, you're putting control and mutuality of obligation on them. A classic example yesterday of some people who were volunteering within a hospitality venue. Genuine volunteers didn't want payment, but they were given 28 pages of documents to sign before they could start volunteering. One of those documents was signing the disciplinary policy. You don't discipline volunteers. They're not there to be disciplined. They're not there to be performance managed. So don't treat them like employees, or, you have a danger that they could morph into employees, and that would definitely not be what you wanted.
Yeah.
Okay. Yeah, and you may get a right to work issue. The Home Office has its own definitions of voluntary worker as compared to volunteer. And you're in a completely opposing right to work position depending on which category you fall into. And it does go to Rebecca's issue about control. Possibly someone doesn't have to have a right to work check or establish a right to work if they're genuinely just turning up randomly and volunteering, and then they walk out of your building as and when they see fit. You just, they've left then. As soon as you've got that thing of, you'll be here at 9, won't you? And you'll go at 12. You start down that route. You start saying there's a right to work issue here. Have you checked who they are and whether they've got visa status or whatever?
Right. Okay. Well, the last area we're going to look at is apprentices. So, Adam, can you talk about the apprenticeship relationship? How does that differ to ordinary employment?
Well, it can be quite close or very different depending on which type of apprenticeship relationship you're in. Just quickly, you've got three broad types. I think when we look at the English perspective, you've got the common law apprenticeship, you've got then the old form of approved apprenticeships, and you've got the new English approved apprenticeship scheme. If you end up in the first one, the common law arrangement, it can be very different. Most notably, as a potentially very costly damages obligation. If you bring the common law apprenticeship to an end and the individual then says, look at my career losses, I've not been able to complete my training, it can become very costly. The other forms of apprenticeship shouldn't give rise to that. They should have the same sorts of obligations and duties on the employer, for example, around termination as an ordinary employee, but it's going to be a tripartite arrangement with a training provider, you and the individual. So it becomes more of a focus on, do we understand the way this contract works, the three parties, their obligations, and how we comply with them?
Yeah. Am I right in understanding that what's really important is to get the documentation right?
Yeah, absolutely critical, because you could accidentally end up with a common law apprenticeship if you don't set it up in a way that complies with the requirements, for example, of what's now called the English approved apprenticeship. And that would be a horrible place to be if the person realizes if you want to bring it to an end, and the person says, I've got a lot of rights here that no other normal employee would have.
And can you employ an apprentice or engage an apprentice for just a short-term project or placement?
Well, it looks like you will be able to under this flexi apprenticeship scheme. And I think there's potentially a bit of a game changer for certain sectors like construction, IT, where there's always historically been a low uptake, not least because they would say, well, how are we going to take on an apprenticeship for at least a year when the construction project we're working on is only 6 months or 4 months? And yes, that's the intention, I think, behind it. So you can dip in and out. Just need to bear in mind some of those practical issues you mentioned, Simon, about agency workers, who's responsible for what, who's doing what, who deals, for example, with a grievance if that gets raised whilst they're on a flexi part of their apprenticeship with us. Is that us? Is it the provider? They will still potentially pop up, but it could be useful.
And how about Kickstart? How does that influence the risks on termination?
At the moment, I mean, there's an FAQs on the Kickstart portal, and it says, this is not legal advice, it says, as with any other employee arrangement, you're enabled to terminate their employment in line with standard business practice. There's a rather sort of blunt description, but clearly the statutory intent seems to be it should be the same as any other arrangement. You need to bear in mind, though, the expectations of the employee. They may be very buoyed up about Kickstart. Oh, I've got a future with you. This is just the start of things to come. That may increase the risk that they'll be very upset and look to find ways to challenge if you bring it to an end. But no, the stated intention is it's the same as any other employee relationship.
Okay, excellent. Well, I think that takes us to 11 o'clock. It's been enjoyable to talk about these different issues. I hope it's been interesting for those who have listened to us. Thank you very much for tuning in, and we look forward to seeing you soon in the future. Bye now.
Thank you. Goodbye.
Thanks. Bye.